back in the 2000s called as a globalized village. And with the globalized village, what has happened is our borders have shrunk as various nations. Of course, we've maintained our sovereignty. We've maintained our territorial integrity as a society. But what has also in recent years happened is the emergence of social media. And of course, social media has also become the leading platform where people communicate and express their views on a number of issues of social, political, and economic nature. Of course, it has also given people the ability and opportunity to receive and send information from various corners in the world within seconds. So it has also become a very instantaneous method of communication, if you will. So what has happened over the years, of course, and in more recent times, is that social media can also be seen as a platform of where people can debate. But they can also have negative consequences in that people can spread misinformation. People can also share very private and intimate images without the permission of people that are in those particular imagery. So what has happened then is, along with that practice, has also come in aspects of cyberbullying and also hate speech. Now, cyberbullying, if I understand it correctly, it has to do with, the same way we understand bullying, of course, but it is now happening at the level of the, that kind of media, social media, Twitter space, Facebook, and of course, interactions between people on WhatsApp groups. So it's the and it can take various forms. It's the incitement of hatred, could be bullying. It's also the exposure of very intimate and private information of a person without that person's permission, but also the impact that would have on the person. So it is intended to harm the person. It is intended to denigrate the image of the person. It is intended to embarrass the person. So it is intended to cause a lot of discomfort to a particular individual that is being subjected to that kind of practice. I can tell you, Matthew, that there's also what we call gaslighting, and what gaslighting does also is that it insidiously, in a subtle way, you push a person to stop expressing themselves, because they start to believe that what they're saying is probably not the correct thing. So even though you believe something about yourself, even though you know that what you are about to say is the truth, it's factual, someone else could make you feel, it could demean you in a way that you start doubting what you're saying and what you're believing about yourself. So bullying is a very, I think it means different things to different individuals, but I can imagine for our children, if they felt bullied at school, they did not want to go back to school, they would develop fear, it will create inferiority complexes in them, but also it will create some kind of a lack of confidence in a person. And so cyberbullying is much more, in my view at least, dangerous, because you are being shared with an entire world. Your world is no longer just Namibia. It's no longer just the location in which you live. It has become other jurisdictions in the world. And the regrettable thing about information, particularly intimate and private information, being placed on social media, is that it probably will never go off. So even if you went to court and got an order that says it must be pulled off, even if, for example, Facebook and Twitter, They have community programs that actually deals with bullying and harassment and those kinds of things. So even if they pull it off, it's been shared quite widely. So in the nutshell, that's my understanding of what cyberbullying is.
Okay. Yeah. And cyberbullying mostly affects young people, especially high school pupils. Statistics
Yeah.
gathered during the first annual school health forum, which took place in 2015, revealed that 44.6% of pupils in secondary school are bullied, with 66% being grade 8 pupils. In a global school-based student health survey completed by 4,531 pupils in 51 schools in Namibia in 2013, bullying proved to be one of the many shocking statistics that Namibian pupils have and still are facing in their education today. Do we have laws that protect us from this?
So let me just state that at the moment, we don't have sufficient safeguards that deal with regulating social media and also specifically addressing concerns of cyberbullying. There is legislation, and I will deal with that in a minute, that deals specifically with electronic transactions and cybercrime. And in there, we have some elements of protective mechanisms in place. But let me just start off by stating that in the Namibian constitution, as you know, the Namibian constitution is the supreme law. So all actions, all laws, all policies that we develop, that we promulgated, that we pass, that we consider and talk about must be subject to the provisions of the Namibian constitution. So under the Bill of Rights, Chapter 3, there are a number of key provisions that could have a linkage with cyberbullying. And I could just state that Article 5 specifically makes the application of the Namibian constitution also applicable between individuals. So it's not just what we would normally see as vertical, in other words, between the state and the individual, but it's also horizontal in that it applies to two individuals. So people must understand, members of the Namibian public must understand that the relationship between two individuals is also governed by the provisions of the Namibian constitution. That's the first point. The second point is we have specific provisions on the freedom of speech, and the freedom of speech, although under Article 21, sub 1A, it provides that all persons have freedom of speech and expression, which shall include, and I want to place the emphasis here, Matthew, which shall include freedom of the press and other media. We could argue that the reference to other media can, of course, include social media. Social media in the spectrum as we understand it, Facebook, Twitter, Instagram even, and WhatsApp. So it certainly is covered under other media. So I'm saying, even if there wasn't a specific provision, I would be able to go to court and argue that other media in that provision include social media. That's the first point. Secondly, we have an important provision under Article 8 of the Namibian Constitution that deals with the right to dignity. Now, you will agree with me that cyberbullying, the sharing, which is a problem that we've been having. I mean, even 2 weeks ago, someone mentioned to me that a lady's private interaction, sexual activity with her partner, at the time her partner, but subsequently her ex-lover, was being shared on social media. So you can imagine the kinds of clearly that's a violation of someone's right to dignity, because all persons' dignity is inviolable. It means it is one of those rights that Namibians have, apart from the right to life. Right to dignity is one of the primary rights that Namibians have. And that really includes both subjective and objective feelings. It's The objective is, how does society see dignity? What are the things that defines people's dignity? For example, having shelter, having going to school, having access to health, those would be considered objectively as aspects that defines dignity. But subjective feelings, how you make me feel, how embarrassed I am, how I cannot think about going to work after the circulation of my face and my private parts on social media, that is embarrassing. It is extremely dehumanizing, I would even say. So that would be a violation of that particular right. Secondly, or maybe thirdly, is the right to privacy, something that we don't talk about a lot, but it is extremely important as well, is the fact that under Article 13 of the Namibian Constitution, the Constitution protects the right to privacy. Now, it is particularly important, Matthew, in this era of social media, where we have seen the dissemination of people's private details, that we protect this right. Now, we have seen, particularly in other jurisdictions, notably South Africa, we have seen that interference with privacy has been expressed in courts, and some of the things that courts have said about it is, and I want to quote a particular case in South Africa. I will not mention the case, but I can just say that it said that a right to privacy encompasses the competence to determine the destiny of private facts. That's important, because what it says is that I must decide how information that relates to my life, whether it is personal or even professional, unless I am dealing with a public office, how information should get to the next destination. That's very important. It's an important principle that guides when we're dealing with issues of cyberbullying. I must decide. Firstly, I decide whether or not I should take a video of any kind, and in what fashion I do it, as long as I do it in the privacy of my space. And then I must decide what kind of distribution should happen, what the distribution channel should be, because privacy and dignity, you must always prove two things when you go to court. You must, apart from the fact that you will prove it's unlawful, in other words, there's a law that is speaking against it, but you must also prove that it's been in the public space, and as a result that it has been the public space, it has prejudiced you. You have suffered harm. And the kind of harm I'm imagining you can suffer is the kind of harm that embarrasses you as a person. Other people will be looking at you differently. People will be teasing you. If you are in school, you can just imagine what a child's life would be like if they have to go back to school after their private details have been shared. I was by accident, while my children at home were watching a South African series called Gomorrah, there was something about children being exposed through the sharing by someone else, not with their permission, by someone else, of a video that had to do with a private conversation between two lovers. So that is the extent of protection we have constitutionally. So you must remember, when we talk about the revelation of public information, private information publicly, what we want to know is that, are you revealing this information because it's in the public interest? For example, what is it that you want to share with the world? Does it have to do, for example, with bigamy? Yes. Is somebody married to two people, for example? Or is a person engaged while they are married to someone else? Is that something that's in the public interest? Is this information that you're sharing, is it making degrading, humiliating, shameful insults, that does not necessarily amount to defamation, but it is of such a nature that it's uncomfortable for you? And also, is the information, like a picture that you're using, it's unauthorized. In other words, I was not, firstly, I was not aware that you're going to share it. In some instances, people don't even know that somebody has taken a picture of them, and now this person is sharing this information, and the information that they're sharing is humiliating, for example, So some of the other things have to do with the fact that a physician, for example, in the medical field, is not allowed to disclose the medical state of a person. And of course, we are also not allowed to disclose the identity of an informer. So the private realm, when we talk before defamation, when we talk about the right to privacy, these would be the considerations that we would consider as the sharing of private information and so forth. Defamation, lastly, just to say that you must remember, defamation has to do with the intentional infringement of another person's right to his good name, and if Matthew, you'll agree with me, our names, our family name, our reputation that we have spent so much time building up is very, very important to each one of us. And yes. So what we need to understand is when it is wrongful and intentional publication of words or behavior which will injure the status of a person, which will injure the good name of a person, which will injure the reputation of a person. So it's important that people understand from that point of view. Under the current regime, you can actually file a civil claim in the courts of Namibia if any of that happens to you. Then, of course, there's hate speech, and hate speech is covered under the Racial Discrimination Prohibition Act, 26 of 1991. And, under that, under Section 11 makes hate speech punishable, criminally punishable. And so it's important that certain acts that are provided for under that section would then be qualified as hate speech. Let me pause here. You may have further questions. So that is more or less the kind of legal regime we have in place to address issues of cyberbullying, maybe not directly, to address issues of cyberbullying and hate speech in Namibia.
Speaking of right to privacy, when it comes to revenge porn, which is now the exposing of pornographic material, the release this kind of material to the public without the consent of the individual in the picture or in the video. So does this mean that this individual is protected by the right to privacy, even though the recording device does not belong to them, and the person that recorded it, they welcomed that person into their private space?
Firstly, because revenge porn, even the language used to describe it is problematic. It's problematic because it tells you here is somebody who wants to hurt someone intentionally. So it has nothing. So if it's a question about the way I would look at it, Matthew, is if somebody's private information is on my phone, and the person has entrusted me, by placing that information on my phone, then I should not break that trust. Integrity dictates that I protect the information that has been shared with me in privacy during a private moment or whatever it is. But if you're using now, so revenge porn suggests that your intention is to embarrass. Your intention is to cause injury. Your intention is to expose this person because for one or the other reason, you have been hurt too. And so the protection that the person would have is to be able to go to a criminal court, to go and make a case at the police station for either crimen injuria or for defamation. Privacy, on the other hand, you can use the constitutional provisions, if your privacy has been violated, to take that to court and to present, and that you could get some compensation for the damage that you have suffered as a result of that kind of violation of your privacy. So that is what exists at the moment. But let me just speak to you a little bit about some of the old legislation that has been in place. I mean, it just shows you that there is need for us to move away now from that 1967 legislation. There was a law called Distribution of Pornographic Material Act 37 of 1967, and under that act, what it was an offense actually for any person to have indecent or obscene photographic matter in his or her possession. Of course, with the Hustler Shop case in 1998, the High Court then declared that provision as unconstitutional. So it means even though it was available then, and because we now had a new constitutional dispensation, the court said no, it was going too far. You would remember, don't know whether you'd remember the Hustler Shop case where the court, was, where people were basically saying we shouldn't allow that kind of activity in the Namibian context. So let me just say one last thing on this point, is that we have the Child Care and Protection Act 3 of 2015, and under that act there is provision for child pornography, and what it does is that it does criminalize the creation of child pornography, but also it provides some support actions to deal with child pornography. But the shortcoming of that provision, in my view, is that it fails to criminalize specifically. It fails to criminalize specifically distribution, dissemination, importing, exporting, offering, selling, and possessing of child pornography. So that's a little bit problematic, I think. But I think we could argue that the distribution of pornography of any nature, of any human being, is a violation of one's right to privacy.
Yeah, especially without their consent.
Absolutely.
Yeah. So, and coming to,
I don't know of anybody. Let me tell you, Matthew. I don't know of anyone, except for if you're a porn artist or a porn star, that would give permission for their private sexual activity to be shared on social media. I don't know of anyone that will do that in their right mind.
Yeah, very true indeed. The Indecent and Obscene Photographic Material Act, the law of 1967, which was more than like 50 years ago, which was before the internet age, is still valid till to this day.
It's valid, but the other parts of the law is no longer is obsolete. It's outdated, because that part that was perhaps important was declared unconstitutional. So it has lost its value, and that's why it's important for us to have come up with a new draft specifically on cybercrime, electronic transactions, and hate speech.
Yeah, because this law looks like it's directly speaking to this issue. It's directly addressing this issue. Yes. Much more than right to privacy, defamation to character. Breaking the law with these pornographic issues. I think this law deals with that. Now, Honorable Minister, when do you think in the near future, are there any plans in place to amend this law and bring it up to date and make it more fitting to the current internet age?
Yeah, so instead of amending that law, which is basically obsolete now, we have come up with two pieces of legislation, which is still in a draft stage. We have what we call a hate speech bill, which will deal with the race dynamics and the tensions that we have around race and so forth. It will specifically address those concerns, because you will remember, Matthew, not so long ago, we've had a lot of issues on social media that was race related. So this hate speech bill will address that aspect, but also amend or maybe even repeal the Racial Discrimination Prohibition Act, because it's inadequate. Section 11 is not enough to address the concerns that we have around hate speech. And of course, the other that is also at an advanced stage is the discrimination bill, and in that discrimination bill will also deal with has quite a nice link to the issue of hate speech. But the one that will specifically address social media concerns around cyberbullying is the cybercrime. It's not a law that is specifically under the tutelage and administration of the Ministry of Justice. It's actually legislation that is being worked on now for quite a while by the Ministry of ICT, and they have expressed that they were at an advanced stage. You must remember now, Matthew, even if you look at that 1967 Act, because it was not challenged until 1998, it was in place. But once you have a constitution, you have to be very, very careful about not bringing in a legislation to address one concern and then to inhibit another. So the challenges that you'd have even around cybercrime has to do with freedom of expression, and also making sure that you are not overreaching as a government. You want to make sure that you are protecting the rights, but that you are not trumping others. So it's a very delicate process that we have to go through, and I think that's why it has taken so long. Also, because it's spanning various jurisdictions. It's not just about domestic legislation. This is likely to have an impact in another country, and then you have to look at your private international law principles. You have to look at your public international law principles. You have to look at conflicts of laws. So it's a convergence of various legal principles that you have to consider, not just your domestic. Because can you imagine if for example somebody has posted something private or intimate about you, and it has now been on Facebook, and you've suffered damage. Let's say you've lost a job, you have lost your reputation as a human being because you may have been a particular individual that was a socialite, for instance, and now you can no longer have your gigs because, or you were an artist, or you're a child at school. I heard about that little girl who was exposed, for example, in South Africa, in front of her friends, and who committed suicide. So I'm hearing these. One of the things I avoid doing is to continue sharing information that exposes people in a very uncomfortable and compromising position. So it's also something that Namibians have to learn, is we have the tendency, when somebody has been exposed, when somebody's privacy has been violated, for instance, we have the tendency to share that. So the more you share, for example, the more you are exposing someone. So we must also learn to stop that kind of sharing in the tracks, so that the information does not go wider than it would have otherwise if we had stopped it at some point.
There was a student some years back at UNAM that was also exposed, I think, under the theme of revenge porn. Now the problem is whether she was a victim or what, because the university expelled her for that. But she now one can look at it and argue like she was the victim of revenge porn, but yet she suffered the consequences after that was she lost her student membership at the university. So exactly. What do you say about that? Like, how do you weigh the justice in that case?
I think it really depends on what the findings are, because you must now also remember institutions, whether it's institutions of higher learning or public institutions, schools, universities, they have a certain decorum as an institution, how they want to portray themselves. And they have rules of discipline and rules of engagements with their students, I'm supposing, about what will bring the name of the university in disrepute. So I don't know the full extent, and I don't have the full facts of the case, but I can imagine that an institution will not be unreasonable if their investigation finds that this person is simply a victim of revenge porn. You would remember that institutions have to make, they have to, they're also, I suppose, the bigger question, maybe, Matthew, apart from the fact that we're saying someone is a victim, and I don't want to actually make it seem like people cannot make decisions about the manner in which they conduct themselves in their private space. I don't want to decide on people's bodily integrity and how they want to use their bodies. So I don't want to be a judge of that. But I think one needs to be cautious about the kinds of decisions you make about exposing yourselves to other individuals in that fashion. Because it gives people power once they have a video about you naked or involved in a sexual activity. But what happens is sometimes your private life, if it has a negative impact on the institution, whether it's an institution of higher learning or a public institution, that institution has to take a decision in their best interest, unfortunately. So it is regrettable that this person has to be victimized for something that otherwise happened in the privacy of their home or their bedroom. But if that private space has now transcended into the public space, you have a problem. So my view would be, I think people just need to be careful about, the principle should be, is what I'm doing in my private space, if it came out in the public space, is it going to embarrass me? And once you've made a decision about whether or not you can live with that, I think you can go ahead and do whatever you need to do in the privacy of your space.
Where do you draw the line between hate speech and freedom of speech?
So it's not a straightforward answer, I would say, Matthew, but I can tell you that the Namibian Constitution values freedom of speech and expression. If you look at some of the decisions, Kaweza comes up, Kaweza versus the Minister of Home Affairs in 1995. For us, a locus classicus case that defines the importance of freedom of speech. So we all know, though, that rights are not absolute. All rights in the Namibian Constitution are subject to justifiable limitations. And so, under that same article that provides for freedom of speech, Article 21, sub 2 of the Namibian Constitution actually speaks to the, how do we ensure that whatever law we pass, whatever rights we have, can be reasonably limited. So you must make sure that whatever it is that you do, whether it is, on hate speech, there's something else. But when you talk about freedom of expression and you talk about freedom of speech, I just want to tell you that you want to make sure that any restrictions that we can make, whether it's private individuals or public officials or government, any restrictions must ensure that it is necessary in a democratic society, that it is required in the interest to protect the sovereignty and integrity of the Namibian nation, that it does not threaten national security, that it does not threaten public order, but also questions around decency and morality. How does it, whatever you were saying, how is it affecting our social fabric? How is it affecting our moral fabric as a society? And also, is it intended, what you are saying and what you're doing, is it intended to defame a person, or is it intended to incite the commitment of violence or an offense? So it's important for people to understand that, yes, we have rights, but there are reasonable restrictions that can be applied to ensure that we protect the overall health, public order, and national security of our society. So if there is a conflict between the right to freedom of expression and one's right to dignity, these are the imperatives that you will have to be looking at.
I just wanted to bring up a scenario like in the United States of America, which is one of the leading powerhouse in the ICT sector. They have a Congress House where they evaluate and thoroughly question creators of various electronic communication platforms like TikTok, Facebook, Twitter, amongst many others. They present their electronic platforms, and then they are questioned, and this is to understand the safety of that service when it's rolled out to the public, and to understand such platform. Here in Namibia, we have CRAN, of course, which is the communication regulatory body that promises to protect electronic communication service consumers from any exploitation or abuse. But they don't hold the power to impede these platforms from being used in Namibia when considered unsafe. Unlike at the Congress House in the States, where they can decide that this platform is not safe for our community, so we are not going to allow it. The only house that has such power is the parliament. My question is, do we see our parliament take up that similar role in an attempt to fight online harassment, to scrutinize and...
So I'm not sure that parliament, because I don't know, the United States is a very different system in terms of both their legislative, judicial and executive functions. So maybe not the best example in terms of what we can borrow from in our setup. But what I can tell you is the electronic transactions and also the cybercrime legislation that is pending, is intended. Firstly, I think the Ministry of Information, Communications and Technology, as the administrator of that envisaged legislation, is intended to cover aspects of dealing with online offenses. Now, if you are dealing with online offenses, it will be treated like any other offense. So your law enforcement would be the ones that should monitor. If you go and complain about it, we can think about how law enforcement can get involved. But I'm imagining that legislation that is envisaged on cybercrime would be intended to develop offenses, online offenses specifically, and also to develop safe, secure, and effective environment for consumer protection when it comes to how do we manage the social media space in the Namibian context, for example. So I know that bill, at least in its draft form, has created offenses around distribution, around production of child pornography, of electronic harassment, of making false representations and providing false information online. So that is the intent behind that piece of legislation. And I'm sure that the legislation then also has institutions that will monitor the implementation of those provisions. Now, I know, for example, Facebook and Twitter and Instagram has what they call social media platform policies, and what they do. So because Facebook has that, because Twitter has that, and Instagram has that, Namibians obviously are also subject to those policies that those institutions have provided. And I mean, people have enjoyed some protections as a result of those policies. I mean, specifically because they do focus a lot on what they consider harassment. They focus on their policies. They focus on cyberbullying. They focus on sexual exploitation of adults and children. And also they have a policy, because I went in actually and I looked at their policy framework of when non-consenting adults are sharing intimate images without permission. So I think they provide information to the user on how to use it and also how to protect themselves against these actions. So these major platforms, I think, provides us with something that we can borrow from if we want to develop a domestic kind of policy framework for educating our people about cyberbullying, for instance, or sexual application or human trafficking, for example, and any images that have been distributed that we all know would cause some kind of discomfort, you can report, and once it's reported, it can be pulled down. So that is the kind of learnings I think we can take to when we develop our own cyber spaces.
Lastly, but not least, the use of mobile phones in public. It's very few of us Namibians who understand that when you are with your mobile phone in public, you actually have the right to record whatever is public. Just a message to the Namibian people. What do you think, what can you tell and advise the Namibian public in this regard, the use of their phones in public and what they feel? Previously, we have seen people being harassed by law enforcement officers who probably also don't understand that an individual have the right to record them in public because they are public servants, of course, and apart from that, they are in public. But then such individuals suffer harassment. So what is your message to the public for them to understand?
So I just want to say two quick things before I get to that point, and that is, Matthew, we need to understand that, you know, the kind of society in which we live has become boundaryless. So we don't have boundaries anymore like we used to. And what we've also seen is the use of mobile phones in public have also, in some instances, saved lives. So we unfortunately, it is one of those things we cannot control. You know, what I would suggest Namibians do is the manner from a private perspective. I think the manner in which you conduct yourselves in the public space is very, very important, because you don't know who's seeing you. You know, we have basically big brothers all over. There is always an eye, and this is not the government, for instance, you know, that is recording people. We have CCTVs in people's homes, in shops. So everywhere you go, people will notify you that, you know, there is a CCTV camera in here. So how you conduct yourselves is really up to you. But we are notifying you that you could possibly be recorded. Now, CCTV cameras, people recording crime scenes and things like that. It has, you know, there has to be a balance, because, you know, crime scenes, depending on if you're the police officer and you're the investigator, you want to ensure that it's away from the public space because it may compromise your investigations, for instance. But it's something we cannot control, what people do with their private phones, you know. But we've also seen instances where the recordings by a private individual from the top of their office, for instance, has recorded, you know, people robbing someone and things like that. So for purposes of crime prevention, I think, you know, we should encourage it, but I think how people conduct themselves in private but also in public space is extremely important. And I would suggest, you know, that especially young people, you know, and you are not in a trusting environment. You know, you don't know these people that you're interacting with, where they're coming from, what their intentions are. I would not let anyone record any activity that takes place in the privacy, particularly of my bedroom. So it's important for young people to understand that it is not something that is advisable. Somebody should never make you feel that you need to record, you know, sexual intercourse with them, for instance. For what good purpose would that be, you know, that you are exposing yourself in that way? Particularly because at the press of a button, all that information can become very public. So I discourage young people, or anyone for that matter, including myself, from engaging in any activity that if it came out in the public, that it will be embarrassing.
Just 2 weeks ago, I had the same conversation with private law practitioner Norman Chombe, And then he stated that...
You see, possession of pornographic material, if it's pornographic material, is a criminal offense, first of all. So there will be a problem with whoever has it on his or her device, because you are possessing that.
I think if somebody, everything is about consent. So do you have the consent, the permission, the authority to record any information that you have? I think people have a right to decide how they want to conduct themselves. It is within their private right. It is people's bodies. People can decide how they want to interact with others, But what I'm saying is, if it is intended to hurt the person, for example, the other party would then be liable in law, but it would be considered a criminal offense of injuria or defamation or whatever it is that we call under a common law criminal regime. But I don't think it's illegal, yes, to record someone without their permission. And even worse, if it is without them knowing that they are being recorded. But I think if somebody agrees, and they're at the age where they can agree, if they are 18 years and older and they can decide how they want to conduct themselves, I don't think it's illegal, but it is certainly illegal if you did not have the permission to do so.
Okay. Yeah, before I let you go, Honorable Minister, just to clarify, so that means if I want to act proactively, instead of me waiting for this material to come out in public, I know the fact that this individual have a recording of me in private without my consent before it's even released to the public, so I can still file.
Yes. So two things. Firstly, don't do it if you can. But if it has now already happened, and you know that this person has intentions to do that, you can do two things. The one thing that you can do certainly is to get a restraining order so that the person does not publish or distribute or share that particular material on social media. So you can use that. I mean, it's a very expensive kind of approach. But I think under the Domestic Violence Act of 2003, I know that there is only mention of harassment and there's mention of stalking, for instance. And I'm just thinking now, without having applied my mind properly, that probably, particularly if you're in a relationship with the person, or if you're in a relationship with the person, for example, I think people can try and approach the domestic violence court, if they meet the requirement under domestic, whether they meet the requirement of a domestic relationship. I think you could possibly get a protection order, and as part of that protection order, you could ask the court that the person not be allowed to distribute any information on their phone that has to do with their intimate interaction and so forth. So I think there is a possibility under the Domestic Violence Act there for prevention purposes, but definitely a restraining order or an injunction, as we call it, would help in stopping them from distributing the material that has intimate information of the person.
Thank you very much for your time, Honorable Minister. And that's it from me, unless there's something in conclusion you want to, we probably left hanging here and there. You can.
I think for me, from a justice perspective, I think one of the things we realize is the importance of privacy and bodily integrity of a person. And I do want to just say that, especially our young people, particularly those at school, really need to look out for who they're hanging out with, how they conduct themselves, what kind of substances they're exposing themselves to. So that, because when you are in a space where you are drinking too much or you're smoking too much and there's a lot of noise, a lot of things happen. So you need to be conscious about your environment in which you find yourselves. But also human trafficking is very real in the world, but also it's becoming an increasing problem in Namibia. And we are concerned about the number of missing girls in our country. So I just want to say, whilst we are strengthening our laws and we are looking at how to improve our law enforcement activities, we do ask individual members of our society, particularly our young people and our parents, to teach our children and create awareness around some of these social evils that we are finding in our society. There is a need for our children to be vigilant.
Thank you very much, Honorable Minister.
Thank you very much.
Thank you very much, ma'am.
Thank you. Goodbye.
Goodbye. Have a blessed day.
Thank you.
Thank you for watching. Like and subscribe and hit the notification bell for you to be notified when we upload new content. Thank you and cheers.